Hello viewers. Today, we will discuss about an appeal against decision by the Immigration and Asylum Tribunal. We will cover brief overview, how to appeal, hearing, the tribunal decision, and legislation and previous decisions. You can appeal to the upper tribunal, Immigration and Asylum Chamber, if you think there's a legal mistake with a decision made by the first-tier tribunal, Immigration and Asylum Chamber. The tribunal is independent of government. A judge will listen to both sides of the argument before making a decision. Help you can get. You can get legal advice, including from a solicitor, or help from a regulated immigration advisor. You can also contact Citizens Advice. You may be able to get legal aid. Read the guide on representing yourself, if you're not going to have a legal representative. You may be able to get asylum support, for example, while you're waiting to find out if you'll be given asylum. How to appeal. You must be able to make a case for why the decision was legally wrong. For example, if the tribunal did not apply the correct law or wrongly interpreted the law, did not follow the correct procedures, had no evidence or not enough evidence to support its decision. Ask for permission to appeal. You must ask the first-tier tribunal, Immigration and Asylum Chamber, for permission to appeal to the upper tribunal. You'll be given the form to ask permission from the first-tier tribunal, Immigration and Asylum Chamber, when you get your decision. Send it with a copy of the decision to the address on the form. Deadlines for asking the first-tier tribunal for permission to appeal. You must ask for permission to appeal within a certain period of time of getting your decision. When you must appeal by depends on whether you're inside or outside the UK. When you're inside the UK, 14 days after the date on the written reasons for the decisions. You're outside the UK, 28 days after the date on the written reasons for the decisions. Fees. There is no fee to appeal to the tribunal. If you're refused permission to appeal, you can apply to the upper tribunal for permission to appeal, if the first-tier tribunal refuses, or only gives your permission to appeal on limited grounds. Download and fill in the upper tribunal permission request form, and send it with the appropriate documents to the address on the form. You must also say whether you want a hearing or not. If your case was heard at either the Yarl's Wood or the Harmondsworth Hearing Centre as a detained immigration appeal, send your application to the Harmondsworth Hearing Centre. Deadlines for asking the upper tribunal for permission to appeal. How long you have depends on where you are and how you received your refusal letter from the first-tier tribunal. When you're inside the UK, 14 days after the date on the decisions. You're outside the UK, 1 month after the date on the decisions. Documents you must send with your application. Include copies of the following documents with your form. Include copies of the following documents with your form. The decision by the first-tier tribunal. The notice of refusal of permission to appeal by the first-tier tribunal, or the refusal to admit the application for permission. A statement clearly setting out your reasons for why you think the first-tier tribunal made a mistake. Any other relevant documents that you sent to the first-tier tribunal. You also need to include any written evidence that shows why you think the first-tier tribunal made a legal mistake. If your application is late, you must explain in writing why it is late. The tribunal will then decide if it can review your application. Ask for a hearing. You can ask on your application to be made either just on the information in your application, at a hearing that you or your representative can go to. The tribunal can decide to have a hearing, even if you do not ask for one. You'll be told if this is the case and invited to attend, if you're in the UK. If they do not hold a hearing, a judge will decide your case based on your application. Withdrawing your appeal. Only you or your representative can withdraw your appeal. Contact the tribunal in writing. If you want to withdraw your appeal, include your appeal number. The tribunal will decide whether to give you permission to withdraw, or if the hearing will go ahead. If your hearing is less than 7 days away, contact the hearing centre where your appeal is scheduled. If you have a hearing, you or your representative will be told when and where your hearing will take place. You can check the daily courts lists on the day of your hearing to find out if anything has changed. You may need to first, where the tribunal will check that you're ready for the full hearing to take place. Bring copies of all the documents that you gave to the tribunal. You can bring a friend to represent you. Ask the judge at the beginning of the hearing if this is the case. If you or your witness or representative is outside the UK and wants to give live video or audio evidence, contact the tribunal to request it. Tell the tribunal what country you, the witness or representative, is in, and what type of evidence is being given. You must do this as soon as possible. Private hearings or hearings by video. Hearings are usually carried out in public. If you have an important need, for example you think you'll be put in danger, if you go to the hearing, you can ask for your name not to appear on any tribunal documents or court lists, for the tribunal to be private and not open to the public, to attend the hearing by video link. Ask judge. You can ask for a male or female judge if you think there are issues in your appeal that make it appropriate. The tribunal will decide if it can do this. Make your request as soon as possible when you apply, and no later than 7 days before the hearing. If you cannot attend the hearing, you must attend the hearing yourself, if you're in the UK. You can also bring a solicitor or regulated immigration advisor with you. If you're not in the UK, you can ask a solicitor, regulated immigration advisor, or the person who supported your application, your sponsor, to attend the hearing in your place. You can only be represented at the hearing by a solicitor or regulated immigration advisor. Your sponsor cannot act on your behalf. Your sponsor cannot represent you at the hearing, they can only be told the tribunal's decision, given information over the phone. You must write to the tribunal to tell them if your sponsor will be attending. Include the case reference number of your appeal. If your appeal cannot be resolved at the hearing. If your appeal is not held on its scheduled day for any reason, for example, there is not a judge available, it'll be adjourned and rescheduled for another day. Your hearing may also be adjourned as part heard, if there is not enough time to finish it, or it cannot be resolved on the day, for example because more evidence is needed. The tribunal will arrange another hearing with the same people present. Children at the hearing. You cannot take children into the hearing room with you. If you need to bring them to the tribunal, you'll need to bring someone to look after them. The tribunal's decision. You'll normally get your decision in writing in 28 days. If you win your appeal. If the upper tribunal decides that a mistake was made, it can overrule the decision and make its own judgment. Order the first-tier tribunal to hear the case again. Decision of the tribunal. If you lose your appeal, you may be able to appeal to a higher court if you think there was a legal mistake made by the tribunal. Ask for permission. You must write to the upper tribunal and ask for permission before you appeal. How long you have to do this depends on where you are and how you received your decision. Refusal letter post by 12 working days, if you're inside the UK, for outside 38 days. Refusal by email or delivered personally, 10 working days for inside and outside of UK. Once you have permission, you should appeal to the relevant higher court. The Court of Appeal in England and Wales. The Court of Session in Scotland. The Court of Appeal in Northern Ireland. You must do this within 28 days of being given permission, England and Wales. 42 days of being given permission, Scotland. 21 days of being given permission. You may have to pay court fees and the other party's costs. If you're refused permission, you can ask the relevant higher court for permission. You must do this within 28 days of being refused permission, England and Wales. 42 days of being refused permission, Scotland. 21 days of being refused permission, Northern Ireland. All related link has been mentioned in the description box. Thank you.